mic. I have to remind you.
Mr. Canning, please take your seat, Commissioner. I've always wanted to do that. Thanks, Gina. Just so everyone is aware, we are streaming this and we're making a video for the staff that couldn't attend today, or if you have to leave. I know a lot of you have meetings later in the afternoon, and so you did not know if you would be able to stay for the whole training session. So if you cannot stay, do not worry, there will be a video and you can always watch that at a time that at a blocked out time in your schedule. I want to thank everybody on behalf of the supervisor, on behalf of the town attorney. We want to thank everybody for coming today. It was very important that we schedule a training on the open meetings law and on the freedom of information law. And we have with us today the most esteemed and renowned and legendary Bob Freeman, the executive director of the Committee on Open Government up in Albany. I have, or actually Marie has on my behalf, thank you, Marie, is distributing copies of the open meetings law and copies of the freedom of information law. The website information is at the end, and the information on the Committee on Open Government. I did not, however, remember to write Bob Freeman's number down. So I'm sure Bob is going to give you that number, and I want to let all of you know that he has been phenomenal in terms of answering questions and providing information. So if one of us in the town attorney's office can't help you, or you have a question about something else, you can always reach out to Bob yourselves. So having said that, I am going to turn the microphone over to Bob and let him train us all, including me. And he did say that he will take questions throughout the program. So if you do have a question, you don't have to wait till the end to ask the question. Bob.
Thank you so much.
Thank you.
Thank you. Esteemed, huh? If I'm so esteemed, why am I the guy who goes home and washes the dishes and folds the laundry? Yeah. It's a great pleasure to be here. I am here for you. I am completely unprepared. I can talk about this stuff from now until doomsday if you let me. But if you do, we'll miss the issues that are really important or troubling to you. But I want to give you just a brief introduction. Again, I work for a very small state agency called the Committee on Open Government. The committee is a unit within the Department of State. I say small. The staff is 3 of us at full strength. We are the smallest state agency that actually does anything, and I will leave the rest to your imagination. And many of you, I'm guessing, have spoken with our assistant director, also an attorney, Kristen O'Neill. Certainly, when you have a question or a problem and you can't find the answer, pick up the phone. I'll give you the number right now, and I'll repeat it later. It is, and I should tell you, by the way, I am told that I hold the record for having the same telephone number for the longest time of any state employee. I've had the same phone number, this is an admission against interest, since 1974. Your eyebrows just went up in the back, yeah. She's saying 1974, way before you were born. 1974, it's area code 518-474-2518. And I should tell you that I have what I've considered forever, and now you know why, the best job in state government. The function in the scheme of things is relatively simple. We offer advice, opinions, guidance, training to anybody who wants to know about public access to government information in New York, primarily in relation to 2 laws, our Freedom of Information Law, many of you know it as FOIL, and the Open Meetings Law. And when I suggest to you that we give advice and guidance and training to anybody, I mean exactly that. We take loads of inquiries from people like you. In fact, we get more calls from local government officials than any other identifiable group. We also hear from state agency employees for obvious reasons. We hear from members of the public and the news media. And the only goal is to give what we believe to be the right answer under the law, regardless of the source of the question. So we're not there necessarily to support the government. We are there to do the right thing. And that is not suggesting that the government necessarily does the wrong thing, but there are some who tend to believe that that is so. How many of you are familiar with our website? not nearly enough. We have a ton of information that's available at your fingertips. The website is easy to find. If you simply Google COOG for Committee on Open Government, or Committee on Open Government, or FOIL, or my name, you will get there. And when you do get there, you'll see several topical headings, one of which will say Freedom of Information Law, another the Open Meetings Law. As you scroll, for example, to Freedom of Information Law, you'll see a series of drop-down boxes. One of them will say Text of the Law and Regulations. You want to find out exactly what the law says, you click onto that. Another one will refer to Frequently Asked Questions. For so many people, if you go through the FAQs, it will provide the kinds of answers that you need. Most important for so many people, we write advisory legal opinions, and they are indeed advisory. You read an opinion, you don't like it, you can throw it away and say, Freeman just doesn't know what the hell he's talking about. That is your choice. That's your choice. The hope, of course, is that the opinions are educational, that they're persuasive, that they encourage knowledge of and compliance with law. And we've written, and this will sound a little nutty, we've written over the course of years in the neighborhood of 25,000 advisory opinions. They are indexed by key phrase. The key phrase indices are, we'd like to think, intuitive. So if you have a question about payroll information, you click onto P and scroll down to payroll information, and the opinions that have any sort of precedential value that have been prepared since 1993 are available online in full text. That's when we first got our computers. So again, many of your questions can be answered by means of the opinions. If you cannot find what you want via the alphabetical index, on the page with the alphabet is a search box. You enter the word or phrase that pops into your head, and that too will lead you to the full text of advisory opinions. So the website is used. We have hundreds of thousands of hits every year. Use it with impunity. Use it with impunity. Use me. Use Kristen. We are there to be used. Some of you were probably told that we'd be talking about the Open Meetings Law first. We're not going to do that. I was told that some of you have nothing to do with a board or a council or a commission, and you'd rather know about FOIL. So unless there's an objection, we'll talk about FOIL first. Any objection? Good. Then we'll talk about FOIL first. And the first point to make is that the title of the law is at least a little bit wrong, at least a little bit misleading. Why? It is not an access to information law per se, it is an access to records law. It's not a vehicle that gives John or Jane Q. Public to ask questions and require that you answer them. You can. We do it all the time. But that is separate from any responsibility imposed by FOIL. FOIL generally deals with existing records. If somebody goes to Jim's office, the town clerk, and says, can you give me the total that you spent on heating the town hall last year? I'm going to guess that you don't have a total. You probably have what most of us have, 12 monthly bills. Now, he could say, if he doesn't like the person who's making the request, sorry, we don't maintain any such record. We're not required to create something new on your behalf. See you later. Or he could say, well, we have 12 monthly bills. If you want those, you can create your own total. That would be absolutely fine. And I often refer to what I've come to call the Spike Lee principle. Anybody know what that is?
Do the right thing.
That's it. You've heard me before, right? You do the right thing. I will sprinkle this presentation with various allusions to, let us say, music over the course of years. That's a film, but the shoe fits, so we wear it. So again, FOIL pertains to existing records, but one of the distinguishing features of our statute in New York is that it applies, number one, to all government agency records, and number two, it defines what a government agency record is. Now, you'd think that that would be a common feature of access laws around the country, around the world. And many of you know that there is a federal Freedom of Information Act. It applies to federal agencies only. Every state has its own version of an access to records law. Every state has its own version of an open meetings law as well. They're all at least a little bit different. In any case, we looked at the Federal Act, which was substantially amended in 1974 on the heels of Watergate. And that was the year that the first version of FOIL was enacted in New York. We tried to look at the Federal Act and determine where its deficiencies might have been. And one of those deficiencies involved the absence of a definition of what a federal agency record might be. And to this day, there are issues that percolate through the federal courts, which involve who prepared it, where did it come from, what is its function. We all know about issues involving, let us say, email Hillary Clinton's, associates of Donald Trump. Email issues arise all the time, and they focus to some extent on what is a government agency record that may be subject to the Federal Freedom of Information Act. Well, we resolved those kinds of questions here by 1978, when the essence of the current version of FOIL went into effect. And think about 1978. In the back, you who raised your eyebrows, can you think of 1978? Can you recall 1978? No, you weren't born yet. Well, high tech in 1978 was an electric typewriter. We used carbon paper to make copies. You know what carbon paper is? Tell the truth. No, she doesn't. That's a funny, I speak to college kids, they have no idea. They have no idea. Be with you in a second. Computers, it was the beginning of the era of the computers, but the reality is that the computer that was the size of this podium could do less than the phone that everybody carries on him or her. But we got lucky. We got lucky, at least in my opinion, we did. And since 1978, FOIL, again, is applied to all government agency records and has defined the term record expansively to mean any information in any physical form whatsoever, kept, held, filed, produced, or reproduced by, with, or for a government agency. So if you've got it in some physical form and it contains information, or if it's maintained for the town, it constitutes a government agency record that falls within the framework of FOIL. Yes, sir?
Oh, I'm skeptical. You're talking about...
You're skeptical?
Yeah, I'm skeptical because they say if you remember the substances, you weren't there. So, what are you...
What a guy. I was asked to repeat the questions. I'm not going to repeat that. What if, Some of us, never mind. I told you how long I've been working for the state, so that's enough of a giveaway. Now, the question from there, it's a record, is it public? And FOIL and the Open Meetings Law, to my mind, are based largely on common sense and reasonableness. All they ever say, and this is something of an oversimplification, is that everything is open. Everything is available except to the extent that disclosure would hurt significantly either somebody in terms of an invasion of privacy, the government in terms of its ability to do its job well on behalf of the public, or on occasion a private company vis-a-vis its competition. So the real question in so many instances is fairly simple. What would happen if we had to disclose? What would happen if we had to discuss this issue in public? And unless the answer in the gut is, ouch, this would really hurt, chances are pretty good that openness and disclosure should be the outcome. Now again, that's an oversimplification. We have too many laws in New York and they're not necessarily consistent, but that is generally the way I think we should view open government laws in New York. Questions? No questions? Come on, there must be questions. We'll talk a little bit about procedure. Every government agency is required to designate at least one so-called records access officer. In most towns, it's the town clerk. Here it is as well, Jim Altadonna. You're the records access officer. And his role is to coordinate the town's response to requests for records. So if a request comes in and he doesn't have the physical custody of the record, he does have legal custody because that is one of the ingredients in the town law, Section 30, you're supposed to cooperate with him. And whether or not you want to disclose the record that happens to be in your physical custody, your desire really doesn't matter very much. You might consult, you might offer guidance concerning the effects of disclosure, but it's his determination as Records Access Officer to figure out what's public and what's not. Questions about any of that? No questions? Please. Yes, good.
I have a question about the electronic component. So I think a lot of people now have access to emails and things through online servers. So like, let's say you have a Gmail account and you access it from your town computer. And that account may possibly have some personal, some outside business, and some town.
Stop. Remember that song? Hollies, 1966? Who remembers that? Come on, only old people do, I guess, right? Again, you look at the definition of the term record, and one of the things that I have to do when I get into the office in the morning, I turn on my computer, I have to click onto a box that says, okay, and I'm agreeing to a variety of conditions imposed upon me by the law in New York, imposed upon me by the Department of State. Whatever comes in belongs to the Department of State. Whatever goes out belongs to the Department of State. So if my daughter sends me pictures of my grandchildren, they're on my computer at work. They are records as defined by FOIL. Now, chances are pretty good that if a request came in, I could deny access based upon the exception involving unwarranted invasions of personal privacy. But the reality is we breed only unusually adorable grandchildren, and I would not care. I would not care. Second, and also commonplace these days, do town board members here have offices in town hall?
Yes.
You do? How about planning board members, zoning board of appeals members, yeah? Do you ever, as board members, communicate with one another or with constituents from your private offices or from your home, sitting down at your own computer and transmitting or receiving an email communication that relates to town business? When that is so, those communications also are records as defined by FOIL. And if you're really interested, again, you go to our Index to Advisory Opinions, click onto E, scroll down to Email. Email, and I have a favorite opinion. It's number 15893. It involves a question raised by a town board member who asked very simply, I go home, I sit down on my personal computer, and I communicate with other town board members and members of the public regarding town business. Are those communications subject to FOIL? And the answer is clearly yes. Whether they would be accessible under FOIL or otherwise, again, is dependent upon the content of the record and the impact of disclosure. Does that answer your question?
I think so. What about cloud-based services, though? Like something like Google, where you're not actually downloading it onto the computer?
Are you talking about your ability to acquire information, or are you talking about something that was produced or acquired by you or somebody else in your capacity as a town employee? You know, if it relates to your governmental function and it is stored in the cloud based upon your governmental function, sure, it constitutes a record. And more material is being stored in the cloud. It doesn't make any difference where it's stored. The question involves the connection between the information and the governmental entity.
Okay, but so here's my question.
Yes.
I get a picture of one of your adorable impish grandchildren.
Impish? Did I say impish?
Yeah.
The shoe happens to fit, but that's okay.
It's just a guess, a lucky guess. You store that in the cloud, but you access the cloud via your town computer.
Yes.
So you're signed into the cloud, you're doing work, your grandchildren don't necessarily relate directly to the town. Are those now foilable if you do not download?
They are subject to rights conferred by FOIL. Yes, no doubt about that. There's no doubt about that. You know, going back years and years and years, you know, are they yours or do they belong to the government agency? Anybody here remember the Moonies? Anybody remember the Moonies? Are you one of the people who got married at Madison Square Garden with 14,000 others? No. Actually, one of my wife's first cousins was among the 14,000. It was a cult. It was a cult, a religious cult, and the Moonies were involved in some sort of a dispute with the Board of Regents. They went to the meetings, they got the minutes, and they said to the secretary to the Board of Regents, Mr. Secretary, we want your notes. We want your handwritten notes. He said, they're mine. The court said, they are records as defined by FOIL. They are not personal to him. He may have prepared them. For the same token, and this comes up periodically, anybody remember Mayor Koch? Yeah, well, you're an old guy, so you remember him. He maintained his own calendars, his own appointment books, and they were requested by the Daily News, and it was the same thing. They're mine. And the court said, they are records as defined by FOIL, and in that kind of situation, we look at the content. Now, if there's a reference to a meeting with the commissioner of such and such, or whomever that's associated with government, certainly that entry would be public. But if the entry involves the dentist appointment next Tuesday, that is unrelated to so-and-so's governmental function, that item could be redacted prior to disclosure. Okay, questions? Yes, sir.
Working papers.
Working papers, like?
Preliminary drafts, not the final product, subject to change, not necessarily reflecting the final product.
The question involves so-called working papers, drafts, items that are subject to change, things that are not final. They are indeed records. They are records as defined by FOIL. FOIL does not distinguish between the working paper or the draft and any other storage medium involving information, if you will. Now, for what it's worth, if you're talking about your drafts or drafts of anybody here, that leads us usually to one of the exceptions in FOIL. We might as well talk about it. How many of you are familiar with the phrase interagency and intra-agency materials? A few, but not enough. Not enough. I'll ask another question. How many of you are old enough to have taken Latin? I'm so old, even Jewish boys took Latin back in the olden days. Yeah, at East Meadow High School, in fact. Interagency, between or among agencies, from you at the town of Oyster Bay, an agency, to me at the Department of State, an agency. Intra-agency would be the internal kind of communication or record, the draft, the working paper. They are indeed intra-agency materials. Now, as we look at that provision, it is curiously written. It doesn't tell us what can be withheld. Instead, it says, yes, interagency and intra-agency materials may be withheld, except for these four things. So what is that exception all about? Well, the Court of Appeals, the state's highest court, has given us guidance. And the Court of Appeals has told us that the exception is intended to enable people in government to express to one another their opinions, their recommendations, their advice, without an obligation to disclose. So if I write to my boss, even though I don't really have one, and say, I think we ought to do this, the I think is clearly my suggestion, it's my recommendation. There's no doubt that that element, if you will, of the communication may be withheld. Not must, but may. But if I'm smart, I'm going to back up my recommendation with something. What's the something going to be? What do you back up your recommendations with? Yeah. And the first exception to the exception that requires disclosure, unless a separate exception applies, involves, and I'll quote, statistical or factual tabulations or data. And the courts have construed that to mean statistical or factual information, regardless of how it appears on the page. It may be numbers appearing in rows or graphically. It may be a narrative expression of fact. I looked up at the back wall and the sign says exit. That's a fact. That would be public. You should also know, for what it's worth, that the courts have held consistently that numbers that reflect estimates, projections, maybe pie in the sky, have also found to be statistical tabulations that are indeed public. So again, if there is something like, in the key case involved, a budget worksheet, 3 columns of numbers, one of them, a breakdown of monies actually budgeted for a particular agency during a given fiscal year. Second column, the agency's breakdown of recommended expenses for the coming year. Third, the budget examiner's recommended breakdown of expenses. Division of the budget said, well, those last two are not final. They're subject to change. They're pie in the sky. They're not real. And the court said, doesn't matter. Doesn't matter. To be statistical tabulations, numbers need not be reflective of, quote, objective reality. So if you really want to protect whatever it may be, present it in the form of a narrative, not numbers, not numbers. I should tell you also that within that exception, the law says that instructions to staff that affect the public are available, as are final agency policies or determinations. Those two in combination have been viewed by many as the so-called secret law of the agency. They're the things you're not going to find in the law books, but you might find in your administrative staff manual or policy book or something like that. It's the working law of the agency. And finally, the law says that external audits are public. So if, for example, the controller performs an audit regarding the town or the village or the school district, even though it consists of a combination of recommendations coupled with the numbers, the audit has always been public. It's public. So when you think about the draft, you consider which portions reflect advice, opinion, suggestion, recommendation, which you can choose to withhold. On the other hand, more often than not, on the other side of the dividing line would be statistical and factual information, which is public. Now, let's say that the statistics and facts don't really mean anything to anybody without seeing the recommendations. Your job is not to explain or interpret. You can, but, if it's in Greek and you don't have an exception, you have to disclose, but you don't have to translate. Same point. You had a question in the... Yes. Good. More questions? Come on. Ask, come on. Other exceptions that are critical. I mentioned privacy before. Do you have Gesundheit, do you have issues involving privacy? Everybody has issues involving privacy. The language of the law refers to the ability to withhold insofar as disclosure would result in an unwarranted invasion of personal privacy. And we see that standard in access laws around the country. You see the same phrase in the Federal Freedom of Information Act, unwarranted invasion of personal privacy. I ask the crowd all the time, anybody know what that means? Nobody knows what it means. Nobody knows what it means. Nobody will ever know what it means. There isn't a judge alive who's in a better position than you, assuming that you're a reasonable person, to make judgments about privacy. As a society, our views about privacy are constantly changing. I offer an example these days that has little to do with foil. Anybody here ever see the Victoria's Secret ads on the tube? Yes? No? Huh? Yeah, some Snickers out there, yeah. Would they have run on network TV 25 years ago? No. Why are they airing now? Because society's view about what is intimate or highly personal or risque, the views have changed. Anybody here have, what are they called? Kids? Anybody have kids? Our kids have different views of privacy than their parents. Our kids are reasonably well known for disclosing information about each other, about themselves, to their friends that their parents would never want to disclose. You're shaking your head, yes, you know. And two equally reasonable people can look at the same items and disagree. I use my own life as an example all the time. We used to have a joke in the house. If the phone rang after 9 o'clock, it was either my mother-in-law or a reporter from Newsday who got kicked out of a town board meeting. Reporters call me mostly at work, but sometimes at night, on the weekend, at home. I don't really care. My name, my home address, my home phone number are in the phone book. Anybody can get them. For those of you who may be unfamiliar with the notion of a phone book, they're available online as well in the white pages. Yes, you can giggle all you want. Phone book, what the hell is that? Yeah. I don't care. My wife, on the other hand, uses a different name. She'd never put that name in the phone book with a home address and a home phone number. Why? 2 reasons. First is painfully obvious. She doesn't want to be associated with me. I can understand that. It's not that funny. Second, she's a psychotherapist. She doesn't want her clients calling her at home on her home phone number, knowing where she lives, knowing that she's married to me, knowing that at certain times of our lives it has seemed that we just have too many kids. She has perfectly good and valid reasons for saying, no, never. I have equally valid reasons for saying, I don't care, and never the twain shall meet. So what do we do about privacy? Well, the Court of Appeals, in dealing with records identifiable to ordinary people, have pretty much said, react from the gut. What would the reasonable person of ordinary sensibilities feel about disclosure of this item? If it's one of those things where the average person would say, wait a minute, this is nobody's business, this is highly personal, it's intimate, chances are pretty good that the government agency either may or must say no. And aside from FOIL, there are numerous statutes, enactments of Congress or the state legislature that forbid disclosure of highly intimate materials, medical records, mental health. If you have kids in school, there's a federal act that deals with student records and generally prohibits disclosure unless you, the parent, consent. What about us? The other branch of case law deals with the privacy of public officers and employees. And the courts have pretty much said two things about our privacy. Number one, we have less than anybody else. Why? We are supposed to be more accountable than anybody else, right? The public is stuck with us, generally until the next election, till budget cuts, my case, till retirement or death, whichever comes first. I've been eligible for both for a long time. Yeah. In fact, I did retire, but we don't have to go into that. Came back 2 days later. People use words like idiot, jackass, never mind. Second, in numerous circumstances, the courts have said that those items about us that in some way relate to our duties, they're usually public. Why? Because disclosure in those instances would result in a permissible, not an unwarranted invasion of personal privacy. That's why you read all the time about the salaries of public employees. Overtime, all public. Our attendance records, time in, time out, leave used, accrued, public. If we are disciplined, generally speaking, if there is a finding or an admission of misconduct on the part of a public employee, it is public. It is public. On the other hand, if there is something like an allegation, a complaint, or a charge, and either it's dismissed or it has not been established that so-and-so did anything wrong, yes, disclosure in that circumstance would result in an unwarranted invasion of privacy. But again, if there's an admission, if there's a settlement, so-and-so is brought up on charges, it happens all the time, it takes too long and too expensive to go through the process under the civil service law or whatever it might be, and often some sort of a settlement agreement is reached. What if one of the terms of the settlement agreement is that the terms of the settlement agreement shall remain confidential? Courts have said you can't do that. You can't do that, it's public. It's public. Now, for what it's worth, a common element of one of those agreements these days involves the inability of either party to disclose on his or her or its own initiative prohibition regarding speaking about whatever the settlement agreement might be. But there is also case law that says that if the request is made under FOIL for that settlement, it's public. It's public because that law requires disclosure. Questions? There must be. Yes, good.
Can you talk about how financial disclosure is?
Sure. Anybody here of Archdeacon? A guy named Archdeacon? Yeah, Tim Archdeacon. Why does the name come to mind?
Oyster Bay.
Because he sued the town of Oyster Bay, which said, you can look at it, but you can't have a copy. And back in the day, and in fact, I told you there are too many provisions of law, and they are not consistent. There's a state agency that deals with financial disclosure. Now it's called the Joint Committee on Public Ethics. It used to be the Ethics Commission. It was something else. In any case, I've been filing financial disclosure statements since 1976. And typical in the statute that deals with those records has been something that said, not available for copying, but it's available for inspection. Not true anymore, but But when ethics laws involving financial disclosure became prevalent right around 1987, 1988, and the general municipal law was amended to require financial disclosure, there was no reference to the inability to have a copy. It didn't say you can only inspect. And we actually wrote an opinion at the request of Mr. Archdeacon that said that at the local government level, FOIL applies, number one, and it says that an individual, anybody, would have the right to inspect and copy, and to have a copy made upon payment of the appropriate fee. He went to Supreme Court, Nassau County, and he won. So, yes, financial disclosure statements are generally available. I say generally. It is not uncommon for the local law, if you will, to include a provision that says something like, as does the state law, if I submit a financial disclosure statement, I can ask at the time of submission that an element be redacted, be withheld from the public if it has no material bearing on the performance of so-and-so's duties. That's relatively rare. I don't care if somebody sees my financial disclosure statement. My life is sort of an open book. You can sit down if you'd like. There are a few seats here. Actually, I've wondered why everybody's sitting back there. You know, this isn't law school. I'm not going to call on people unless they raise their hands. What happened to these first three rows? Shy? Are you shy from Long Island? I hardly believe that. Yes, sir.
At what point can a FOIL request be determined to be too burdensome or too vague? Like if
Ooh, good question.
X that's been going on for 2 years, and he says, I want any and all information involved in the project.
Stop. One of the elements of FOIL that, in my opinion, is far too frequently overlooked involves the requirement on the part of the requester to reasonably describe the records sought. Reasonably describe. We look again at a Court of Appeals decision. By the way, it involves a guy from Long Island, Harold Boom Boom Koenigsberg. Does it mean anything to you? He was in jail for a long time when he brought the lawsuit. The case was decided in 1986. He recently got out of jail. Anyway, Boom Boom wrote to the Department of Correctional Services and said, I want anything you can find by means of my name or my ID number. And they said, what do you want? He said, I want all of it. Well, they came up with, at the time, 2,300 pages of material and asked him again, what do you want? He said, I want all of it. And they said, sorry, you haven't, government agency, you were able to find the records with reasonable effort. Therefore, he met the responsibility of reasonably describing the records. Now it's your job to go through the stuff to figure out what's public and what's not. But the court also said that whether or the extent to which a request meets the standard of reasonably describing the records often is dependent upon the nature of an agency's filing or record-keeping or retrieval system. And that's a question that comes up all the time. You get a request for the any or all, and you know where some of the stuff is, but with respect to the rest, you scratch your head and you say, where do I look? Where do I look? And I offer these days kind of a silly, stupid example, but people get it when I do. It's my phone book example. You live in Nassau County? I walk into town hall, I see the Nassau County phone book, phone directory, whatever it may be, and I say, aha, a government agency record. What's your last name? McCaffrey. I hereby request all the listings in the phone book pertaining to those people whose last name is McCaffrey. Piece of cake. That's how the phone book is written. Last name, alphabetical order. Even if there are 10,000 people with the same last name, the request reasonably describes. You can find them easily. What's your first name? James, not an uncommon name. I come in the next day and I say, now I request all the listings pertaining to those people whose first name is James. Well, gee, the request is specific. You know that there are James there, but you can't find them unless you go through thousands of listings one by one. That's when you tell the applicant, sorry, we maintain this group of records by last name in alphabetical order, not by first name. We're not required to go through the haystack in order to find the needles, even though we know that there are needles there somewhere. See you later. See you later. But what if it's 2018, and the town maintains the same data, if you will, electronically. And somebody can sit at the keyboard, enter a query, and all of a sudden, yep, all the James come up on the screen. Well, FOIL now is said for a number of years, and there's case law going back to 2001, indicating that if we have the ability to extract or generate data maintained electronically with reasonable effort, yes, we are required to do so to comply with FOIL. There is case law dealing with the exceedingly burdensome request where it was a law firm, and they pretty much said, it was like going to the library and saying, I want all the books. And the court said, no, that's not really what FOIL is about. If you go to our index to opinions, you click onto R for request, comma, voluminous. You will find opinions that refer to a case called Fisher and Fisher versus Davidson. And or you could go to our search box on the page with the alphabet, enter Fisher and Fisher, and that will lead you to the decisions. Okay. Does that help you? I hope so. More questions? Yes, sir.
How does when technology outpaces a specific statute?
Man, it has.
Let me give you an example, like municipal law 50G, I believe, says that the question is to maintain a specific bulk of index records. That's some people's anymore. Is there a common sense element?
Absolutely. Absolutely. You know, we look at lots of provisions within general municipal law, books, papers. You know, we don't do that anymore. Clearly, the courts have recognized that is so, and they've just as clearly recognized that the electronic version of what you used to keep on paper is just as much a record as the old-fashioned record. A book doesn't always mean a book. You're welcome. More questions, other exceptions. What ails you? Come on. Yes, good. Two in the back there. You two fight it out. Don't look back. Yeah, you too. Excuse me? An employee's file. Well, what's in it? Ooh, applications. There are all kinds of things. You know, you're bringing up an issue which I talk about all the time. Usually it's called the personnel file, right? Yeah. How many of you have heard on the radio, the TV, read in the newspaper, oh, it's personnel record, it's personnel file, it's confidential. Anybody ever hear that? Huh? Yeah, there's no law that says that. It is malarkey. It is crap. And yet, in this country, too many Americans have become stupid and sheep-like. We hear these things over and over and over again, and we begin to believe that they're true. You know, that's when we begin to lose our rights. That's why we're in the trouble that we're in, and I'll leave that alone. You can use your own judgment in terms of its meaning. But in any case, there's no reference to personnel records in FOIL. You look at the open meetings law, we'll get to that later, and the favorite ground for going into an well, we want to discuss personnel. You look at the 8 grounds for executive session, it's not there either. It's a catch-all. Forget it. Eliminate the word from your vocabulary. The content of so-called personnel records will determine what's public and what's not. You mentioned the application, the resume. We wrote an opinion on the subject a number of years ago, and the Appellate Division, Second Department, your Appellate Division, agreed with me. And the notion was that if, for example, there are certain criteria that must be met in order to hold the job, the degree in such and such, the certification, the license, those portions of the resume that indicate that so-and-so has met the requisite criteria have to be disclosed. Without disclosure, the public has no way of knowing whether the government hired the right person. Concurrently, with any resume I've ever seen, you have a variety of extraneous personal information. The marital status, the hobbies, the work at McDonald's. Irrelevant, and clearly those items would, if disclosed, constitute an unwarranted invasion of privacy. Now, for what it's worth, the courts have also said that one's prior government positions are always public, as they appear on the resume, as is one's general educational background, and people have been surprised at that. Anybody here have a kid in college? I know that we have some recent graduates. Huh? What's on the back of your car? The sticker we advertise. And the court said that, again, Not the grades, but the general educational background would be public. What else within the personnel file are you thinking about? Benefits. The fact that so-and-so receives benefits, if you will, based upon a collective bargaining agreement or something like that, sure, it's public. But if we get into something that is, let's say, more intimate, so-and-so has a claim for medical expenses, does the public have the right to know the nature of so-and-so's medical condition, disease? No, of course not. Of course not. There's case law dealing with attendance records that bears that out. Great story. City of Albany, local reporter went to a local health club, saw a cop there every day. And he said, what are you doing here? And the cop said, I'm on sick leave. Go figure. Anyway, the request was made for records indicating the days and dates of sick leave claimed by that particular police officer. City of Albany said no. Court of Appeals unanimously said yes. Yes, the public has the right to know when and whether a public employee comes to work or not, as the case may be. But the court agreed with my opinion that if there was an indication of the nature of somebody's medical condition or ailment, that would be out of bounds. That element of the record could be redacted to protect privacy. Does that help you? What else are you thinking about? Yes.
Can I ask you, just to follow?
You don't have to ask whether you can ask. You can ask. If I see your hand, I know you have a question. Yeah.
To follow up on Vicki's question, for a prior agency I worked for, when we got a request for a personnel record or a job application, our practice was to redact or black out the street address, but to keep the town, to black out, let's say, a date of birth, to black out a social security number, but we wouldn't black out things like McDonald's or.
Well, that's a
Is that an obligation of the agency?
No.
To redact
No.
street?
Several points to be made. The question involves elements of records that are typically maintained by a government agency relative to its employees. You mentioned them. Working at McDonald's, or what were the other things you mentioned? Social security number, home address, date of birth. Okay. And we split hairs to some extent. Social security number is really easy. There's another section of the Public Officers Law, it's 96A, which specifies that ordinarily we cannot disclose a social security number, absent the consent of the individual. You mentioned worked at McDonald's. That is something that you can choose to disclose. Why? Because FOIL is generally permissive. The Court of Appeals has held, yes, even though you have the authority to withhold in certain circumstances, ordinarily you do not have an obligation to do so. You can choose to disclose if you want, unless there is a statute, meaning an act of Congress or an act of the state legislature that forbids disclosure. You mentioned home address. FOIL specifies, Section 89, Subdivision 7, that home addresses of present or former public employees need not be disclosed. But what if you want to disclose? Well, for whatever the reason, the Board of Education in the city of Buffalo wanted to disclose the home addresses of its employees. The union went bananas, went to court, lost. And the court said, yes, it's true that the home addresses may be withheld, but there is no requirement that they must be withheld. You referred to date of birth. Interesting. The date of birth is not quite like the Social Security number, but it is a rather unique identifier. And there is case law indicating that the date of birth can be withheld as an unwarranted invasion of personal privacy. On the other hand, there's a case, an appellate division decision involving age. Age. The Daily News sued a city agency to get the ages of its employees. And the appellate division said, public, you haven't told us how and why disclosure would rise to the level of an unwarranted invasion of personal privacy. And that leads to another key point. When we deny access to records, and we're sued, we have the burden of proof. We have the burden of demonstrating to a court's satisfaction that an exception was properly asserted. And we can't simply say, yeah, disclosure involves privacy, unwarranted. We have to say, again, how and why that would be so in order to sustain a denial of access. Does that help you on those issues? Good. Yes, sir.
Just to follow up on what James was talking about before.
Remember James Hold the Ladder Steady? Sue Thompson. Really old. Yes, go ahead. I'm sorry. Let's, the question, that's where we go back to the question involves email communications. And what if it's all emails for the past 2 years? You know, I've sort of done a little bit of analysis. I either transmit or receive maybe 50 emails a day, and I work maybe 250 days out of the year. Multiply it, it's insane. It's insane. That's when you cite Fisher versus Fisher, Fisher and Fisher versus Davidson. It's ridiculous. But, what if somebody says, I want the email communications between X and Y, between James and John? On my screen, my Outlook, I have, at the top of the page, I can enter James and John, and I can say search all boxes. I could search either the current or the deleted or the saved. I can search all mailboxes, and it has become far too easy. Somebody mentioned technology outstripping the law. That is a typical case where that is so, where there may be hundreds of email communications between James and John in the past couple of years. And so far, based upon the standard, can you locate and identify and retrieve the records with reasonable effort? The answer is yes. And the difficulty in that situation is somebody has to read them to figure out what's public and what's not. Okay. Therein lies the difficulty. Yes. You have to read them. And you're talking about how long it takes, right? Right? Yes? Should we talk about the time limits for responding to requests? We should. We should. When a FOIL request comes in, the agency has 5 business days from the receipt of the request to do something. And there are several options. You might tell the applicant, yep, here it is, come on in, or I'll email it to you. Great. Or you might say, nope, you can't have it. In any case in which there is a denial of access, it has to be given in writing, and it must inform the applicant of the right to appeal. The appeal by statute goes either to the governing body, the town board, or somebody designated by the governing body. And it may be the town attorney, it may be the town supervisor, somebody like that. Let's say that you need more than 5 business days for whatever the reason, but it's not a particularly onerous request. In that situation, the law says that we must acknowledge the receipt of the request within the 5 business days and offer an approximate date, generally not to exceed 20 additional business days, indicating when we believe we'll be able to grant the request in whole or in part. Third option. Let's say that it's the unusually difficult, voluminous, time-consuming request, and you need more than 20 additional business days. In that situation, the law says we have to explain in writing why we need more than 20 additional business days, and we must also provide what the law refers to as a date certain, a self-imposed deadline. Yes, we promise, we swear, we will make the records available in whole or in part by such and such a date. And again, any delay beyond 5 business days must be reasonable based upon attendant facts and circumstances. So if somebody requests the minutes from last month's meeting, they're clearly public and they're right over there. There's no good reason for delaying disclosure. There's no good reason for delaying disclosure. Let me make a couple of additional comments regarding the need to respond within the proper time. Let's say that you have the request sitting on your desk. More than 5 business days have passed and the town has done nothing. In that situation, the applicant can consider the request to have been denied. He or she then has the right to appeal. And the appeals person or body has 10 business days by statute to do one of two things: make the records available or fully explain in writing the reasons for further denial. What if you acknowledge the receipt of the request, you say it'll be 20 business days, and all of a sudden it's more than a month? Same thing, the applicant has the right to appeal. The same is true in the case of the date certain that may be missed. And that becomes important. Why? Why? Because FOIL contains provisions concerning the award of attorney's fees in the context of litigation. And some of you may know that the governor, I think, reluctantly signed an amendment to FOIL just a couple of months ago. And it says that if, for example, John or Jane Q goes to court and the court finds that the agency had no reasonable basis for withholding, there's a mandatory award of attorney's fees to John or Jane Q. Public. What if that person goes to court and, in the words of the law, substantially prevails, and the court finds that the agency dragged its feet and failed to abide by those time limitations? In that situation, the court has discretionary authority to award attorney's fees. So there's a downside associated with the failure to comply with FOIL. More questions? More questions about FOIL? Come on. Anything. Anything. Should we move to the open meetings law? What time is it? Yes. Okay, hypothetically, I love the old hypotheticals. Yes, I do. We have the president. Yes. Your question trumps the president. Yes. Policy.
Yes.
What's policy?
Or say, a policy of the municipality. Sometimes the policy that is put in place may or may not, they feel, or the municipality may feel, that it supersedes the FOIL.
Whoever feels that would be, what's the word I'm looking for? Wrong. A statute always prevails over a policy. A statute will prevail over a local law or an ordinance. They're typical in that situation are provisions dealing with fees. Fees, agencies in the past have established fees that far exceed those authorized by FOIL. And the courts have said, no, the statute, FOIL says 25 cents per photocopy unless a different fee is permissible by statute. And the term statute has been construed to mean, again, I mentioned it before, an enactment of Congress or the state legislature, not your local policy, not your local law. Yes?
How about correspondence between the town attorney's office and board members or?
How about correspondence between the town attorney's office and board members? The question, I suppose, is whether the town attorney is offering legal advice, a legal opinion, something like that. If that is so, the first exception would apply. And that pertains to records that are, quote, specifically exempted from disclosure by state or federal statute. All of you have heard about the attorney-client privilege. And again, insofar as a town official is seeking legal advice and the attorney is giving legal advice, the privilege applies. The record would be exempted from disclosure by statute. Okay?
Well, but what if it's not a specific request for advice? I mean, we have so many emails that go back and forth between the electeds and the town attorney's office that could be about property acquisition or any number of things. They could all be viewed as possibly in contemplation of litigation.
Forget about litigation. You have an attorney. You have a will, right?
Sure.
Sure. Yeah, maybe you do. You went to your attorney. There's no litigation in the offing there. Your attorney is giving you legal advice, legal opinion. It's confidential unless you, the client, determine to waive the privilege. And it's the same thing in any number of contexts in which a town official will seek legal advice from the town attorney, and the attorney is giving it. Now, if you ask your attorney, do you want to go to lunch tomorrow, or who's going to win the game tonight? Don't have to be an attorney to answer. There's no privileged communication. Does that help you?
It does. Can one board member waive privilege for the other six? What if one board member decides?
That's called chaos. That's called chaos. In my opinion, the answer is no. The client, in the case of the town board member. The client, I would think, is the town board. And I must tell you that there isn't a hell of a lot of case law, but if one member of a board, you have 5 members on your town board, right? 6? 6? So, well, the supervisor is a member. So you have 7 members. Now, if a majority of the board says, yep, we're choosing to disclose, great. But until that happens, it doesn't seem to me that one member unilaterally has the right to waive the privilege on behalf of all the others. Does that make sense to you?
Yes, it does.
I hope it makes sense. I try to make sense, I swear. Yes. More questions? Yes.
We had, we want 4 days of video.
Video of what?
Well, sometimes they're not that specific.
I mean, what kind of, what department?
Public safety.
Public safety. 4 days of video? There are cases and opinions. You go to S for surveillance. We have opinions. So much is dependent upon the facts. If the video camera is in plain sight and it captures what anybody could see in a public place, I think it would be difficult to meet the burden of proof. But on the other hand, if the camera is hidden, the last thing you want to do is disclose the video because it'll indicate the location of the camera. It typical. I hear this in the context of school districts. School districts have hidden cameras. If the kids find out where the cameras are, they're going to go smoke weed someplace else. And you have the same kind of situation. If it is a hidden camera, and, well, I should talk about this a little bit, the distinction between foil and discovery. One is an apple, the other is an orange. What is available under foil would ordinarily be available to anybody. Foil does not distinguish among applicants. And in fact, there's old case law, Court of Appeals law, that dealt with a request by a person who had sued a New York City agency and requested records from the agency under foil. And the agency said, you're a litigant, you can't use foil. Court of Appeals said, anybody can use foil. When you do, you are as a member of the public. The fact that you're a litigant neither enhances nor diminishes whatever right you've got as a member of the public. Separate from that would be other vehicles, discovery, subpoena, what have you, which I would guess would be more significant in the context of surveillance video. Okay. Yes, sir.
Back to electronic records. An entity makes a FOIL request for information within a certain format and a certain group of individual facts from a database.
Can you do it?
With outside programming support.
Okay.
Which may cost $3,000.
Okay.
What do I do?
What do you do? Everybody hear the question? The question involves the situation in which data is maintained electronically and so-and-so wants certain items within a database. And you don't have the ability in-house to extract those items. You'd have to hire an outside firm to do it, and it's going to cost $3,000. Several points. Number one, there is case law that deals with that very situation. A non-for-profit went to the New York City Health Department. This is a case decided in 2001, wanted data contained within a database involving lead poisoning among kids in the city. And the requesting entity said, we understand that there are elements of this database that we have no right to see. We don't want them, but give us the rest. Give us the rest, and we want it in electronic form. Well, the agency said, we don't have a program that enables us to segregate the accessible information under FOIL from the deniable. We would have to alter our program. We're not required to do that. That's the equivalent of creating a new record. Instead, we'll give you a printout, but before we do that, we have to have a couple of clerks sitting over there for a couple of months with magic markers going through it to delete the personal information. The entity said, no good, we're suing you. The judge brought into the courtroom, again, this was 2001, the agency employee that he characterized as the agency's computer scientist, and sat him down at the keyboard, and by means of entering queries, that was the phrase used by the court, he was able to segregate the accessible items within the database from those that were deniable over the course of an hour and a half. And the court said, That did not involve the creation of something new. It involved the extraction of portions of an existing record. And agency, since you were able to do that with reasonable effort, yes, you were required to do so to comply with FOIL. And the court added somewhat editorially, doesn't it make a hell of a lot more sense to have the guy sit at the screen for an hour and a half than the clerk sitting over there for a month and a half? All of those elements are now part of the law. The last part, you can't do it in-house. You'd have to send something out to a private vendor, a private service company. In that situation, yes, if so-and-so, the applicant, is willing to pay the fee, yes, you'd be required to do so, and you have the authority to ask for the fee up front. So what you'd want to do in that kind of circumstance is get an estimate from the private vendor, and you tell the applicant, we can't do it in-house, we'll have to send this out to somebody, but this is what it's going to cost us. And whatever it costs us is what we can pass on to you. We want the money now. Show me the money. Okay. Yes, sir. Good question. Generally speaking, it's what I've come to call the if you can, you must principle. If so-and-so wants to print out and you can do it in paper, great. If they want it on a disk and you can dump it onto a disk, yep, you have to do that. There's a section of FOIL, it's section 87, subdivision 4, which specifies that if you have the ability to make the record available in the medium of so-and-so's choice with reasonable effort and they're willing to pay the fee, yep, we got to do it. Okay. Yes? Isn't it archaic? Some might say so. Actually, as we look at FOIL, there are two clauses involving fees. One involves photocopies up to 9 by 14 inches. The max that we can charge is 25 cents per photocopy. Now, you think about this. FOIL has said 25 cents since 1974. The actual cost of making a photocopy in 1974 was about 6 cents. Today, it's less than a penny. So, yeah, it's archaic, but, you know, what's archaic? What does that mean? I'm archaic, too. The other clause deals with other records, those that are either larger than 9 by 14 or, much more commonly today, those that are maintained electronically. And in that latter situation, the fee is based upon the actual cost of reproduction. Now, if somebody asks for something that's maintained electronically and we can just dump it onto a disk, it takes 5 minutes. We charge based upon the cost of the disk. That's our actual cost, 49 cents. You're probably not going to charge because it costs more to do the administrative chores associated with that than it's worth. On the other hand, if it takes 2 hours or more to prepare the records, prepare is the word that's used in the law, it wouldn't have been my choice. You have the ability to establish a fee that is based upon the hourly salary of the lowest paid employee who's able to do the job, plus the cost of the storage media. And if you can't do it in-house, again, you can send it out, but you pass on whatever the fee might be. Okay? Yeah.
Let's go back to the 20,000 pages that would come out after the redacted gone through by the town attorney. And we've had cases where we've had 5,000 pages that the town attorney's office goes through. Does that same premise hold where you can calculate, I know it's the lowest person working in the office or whatever, calculate a number, give it to the person, the requester, and say, you know, we can fulfill this FOIL request. However, this is the cost of the labor going through the documents.
I don't know if everybody heard the question. The question involves a situation where it's a voluminous request and an attorney has to review it. And the question is whether you can charge for the time expended by the attorney to review. The answer is no. Cannot. Cannot. That does not involve the preparation of a record. It's already been prepared. So-and-so is simply reviewing it. Now, what if somebody says, I want to inspect these paper records? And inspection is free. But what if there's something within the record, Social Security number, that so-and-so has no right to see? You can tell the applicant, sorry, you have no right to see it. If you want a copy from which a redaction is made, we'll make a photocopy and redact from the photocopy, but we're going to charge you 25 cents per photocopy, and we're going to charge you in advance. And often that will dissuade, let's put it that way. Yes, sir.
mentioning photocopies of items that can't reproduce, do a lot of environmental quality review SEQA, and it involves a lot of blueprints or large...
Stop. Let's assume for the moment that those records are public, that you don't have a basis withholding. You invite so-and-so to come in and use your phone. Use the phone, use the camera. It's easy, it's quick, and everybody's happy. Everybody's happy. More. Open meetings law, yes? Are you glad that we talked about FOIL first? Oh, now she's leaving. Okay. I feel completely dissed. I do. I'm losing the crowd here. Open meetings law enacted in 1977. The Open Meetings Law applies to so-called public bodies. A public body is an entity consisting of two or more designated by law, elected to carry out some sort of governmental function collectively as a body, like the town board, the zoning board of appeals, the county legislature, the planning board, the commission on X, the state assembly, the state senate, all of those groups of people who carry out their functions collectively as a group constitute public bodies covered by the Open Meetings Law. A key question that arose on day one: what is a meeting? What is a meeting? And all over the state, various boards, councils, commissions were saying, well, we're just going to get together to talk. This isn't a meeting. We're not going to take any action. It's a workshop. It's a work session. It's a study session. It's an agenda. It's everything but a meeting. Well, we disagreed, as did the Court of Appeals, and as early as 1978, it was clear that any gathering of a quorum, a majority of the total membership of a public body for the purpose of conducting public business, is a meeting covered by the Open Meetings Law, even if there is no intent to take action, regardless of the means by which the gathering is characterized. I still hear about workshops and work sessions and agenda sessions. Assuming there's a majority present, they are all meetings covered by the Open Meetings Law. Question about that? Yeah, good. You are inquisitive, aren't you? I like that. Yes.
With good reason. You said work sessions.
Yes.
So as long as the work session is public, it doesn't violate the Open Meetings Law.
I didn't say that it did. I said a work session, it's a fictional term. It's a meeting. It's like a rose by any other name, right? A rose is a rose, a meeting is a meeting is a meeting. Same thing.
What about if you're communicating via electronic means? Is that,
How so?
well, and I think I emailed you about this a couple of years ago. We have an email chain that's like, someone sent it to all 7 board members.
Stop. Yeah, board member sends whatever it is to other board members, and people say, well, that has to violate the Open Meetings Law. Think about this. A board member sends an email to other board members. One of them is sitting in front of the screen, sees it right away. Another one will see it tonight when that person gets home. A third one will see it tomorrow. A fourth one ignores his email. There is no instantaneous communication on the part of a majority. I don't see that as being significantly different from the old-fashioned inter-office mail. Each piece of mail would go into the mailbox at the same time, but the recipients would all open the mail at different times. Nobody would ever argue that would fly in the face of the Open Meetings Law. On the other hand, if a majority gets together via the chat room, instant messaging, God forbid on the phone, the answer would be different. They would be, in essence, virtual meetings that the public has no way of knowing about. You see the distinction.
I do. To get really into the weeds, have a group text messaging.
It's the same answer. It's the same kind of situation, right? The text messages, they're read by the members at different times, different places, same thing. Yeah.
It's really going to geographic areas. Let's say you have a councilman that's upstate, a councilman that's in some other state, that they want to communicate. And the only means of communication would be through via email. Would that still constitute a meeting, even though the same person?
Are they voting? Are they doing this contemporaneously?
Just discussing what they're doing.
Well, again, you say just discussing. You probably know, I hope that everybody knows, that typically a meeting would involve the physical convening of a majority. But the law has said now for a number of years that a meeting may be held by means of video conferencing. And and this comes up frequently these days, particularly among state boards and commissions. My own Committee on Open Government, we have members in Buffalo and the city and Albany. Our meetings are all held by means of video conferencing. And the notion is that everybody should have the ability to see one another, including members of the public who may be in attendance at any of those locations. If, for example, you hold a meeting and two of the board members are, they're snowbirds, they're in Florida, and they want to vote, they want to participate fully, if they connect via video conferencing and people can be seen in any of the locations where the members are participating, that is valid. Now, if you choose to do that, the notice provision in the Open Meetings Law specifies that if a meeting is to be held by means of video conferencing, that has to be indicated in the notice. It has to indicate where the members will be participating, and that anybody can attend at any of those locations. And, there are some ritzy communities on the South Shore of Long Island where there have been more people at the condo in Boca Raton at the village board meeting there than back in the village. So, yes, you can do that. Nobody guffawed. Okay. Questions about what constitutes a meeting? Every meeting must be preceded by notice of the time and place. Well, people say, well, what about the agenda? Another myth. There's no law that says a word about an obligation to have an agenda. You want to have one? Great. You want to stick to it? Even better. You want to ignore it? That's your choice. That's your choice. The requirement in terms of the Open Meetings Law involves time and place. If a meeting is scheduled at least a week in advance, the law says that notice must be given not less than 72 hours prior to the meeting. If it's scheduled less than a week in advance, the law requires that notice be given, quote, to the extent practicable at a reasonable time prior to the meeting. And generally speaking, the notice requirement today is threefold. Number one, notice must be given to the news media. Given. There's no obligation ever to publish a legal notice to comply with the Open Meetings Law. You might give notice to Newsday and they say, we don't have enough room. We're not going to publish this. That's not your fault. That's not your fault. It's up to the news media to choose to let the world know or not. Second, the law says that notice must be posted in one or more designated conspicuous public locations. It might be on your bulletin board in front of the building. It should not be a different telephone pole every week. Third, the law has said now for a number of years that when you have the ability to do so, you post your notice on your website as well. Okay? Questions about notice? Pretty simple. Yeah.
So,
Who is she?
I'm sorry, I'll go back up last year. I'm one of the council.
I'm just teasing you. I'm glad that you're asking questions.
And I'm glad that you're here, by the way.
It's an educational process for everybody, right? She asks questions that you're all thinking about, but are too shy to ask. You're not shy, are you? I can tell.
So, you said we don't have to have a set agenda or to disclose
You don't.
the agenda. But we've had a lot of discussion over the past few years about walked-on items to our agenda. So if you establish an agenda and you choose to add something to it on the day of the meeting, can you talk to us a little bit about what is and is not allowed? It sounds to me like
It's allowed. You can do it. We can't predict the future. An issue comes up this afternoon, and you have an agenda for tonight's meeting, and it's a different it's up to the board to choose what to discuss or not, as the case may be. Sure. I hear whispering back there. What? Okay. Questions about? Yes, sir. Yep. You're talking about notice of a public hearing? I don't know the answer. I deal with the Open Meetings Law. I hate public hearings. You know why? You have a crazy quilt of laws. You know, the public hearing on your budget is determined in the town law, school district budget, the education law, the village law for villages. I don't know and I don't want to know. That's where you go to your town attorney. Sorry about that. Yes. Yes. More questions? On notice. All right. Now we get to the heart of the law. The law is based, like FOIL, on a presumption of openness. Meetings are required to be conducted open to the public unless there is a basis for entry into a so-called executive session. The phrase executive session is defined by the law to mean a portion of an open meeting during which the public may be excluded. So an executive session is never separate from a meeting. It can never be held prior to a meeting. It must be held as part of a meeting. And as we look at Section 105, it contains a procedure that must be accomplished in public before an executive session can be held. 3 components. Number 1, somebody on the board has to introduce a motion to go into an executive session. Number 2, the motion has to indicate what you want to discuss. Number 3, the motion has to be carried by a majority vote of the total membership, notwithstanding absences or vacancies. From there, we look at the 8 grounds for entry into executive session, and the question is, does the subject matter fit within any of those 8 grounds? Okay. Questions about that? So what's the favorite word for going into an executive session? Personnel. Personnel. Forget about it. Forget about it. The word is not there. And if we think about it, there are dozens and dozens of issues that we could characterize as personnel matters. Some of them may be discussed in private, some clearly cannot. Let's say that the board is discussing the budget, and they say to themselves, things are kind of tight this year. Do we really need a police department? If we get rid of the police department, we're going to have to lay off people. It's a personnel matter. Goodbye. No basis for going into an executive session. Why? Because the issue involves policy. Policy, how do we choose to allocate public money as the governing body of a public corporation, a multi-million-dollar corporation? Is this function really important to our residents? Policy questions. On the other hand, if the question involves a particular employee, should we keep this person or can this person? The focus in the words of the law involves a particular person. And there would be a basis for closing the doors. Why? Because the exception is precise. This is what it says. And I will quote. It says that a public body may enter into an executive session to discuss, quote, the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. So to qualify, the issue must focus on somebody or some specific corporate entity in relation to one or more of those modifiers. If your motion to discuss whatever it may be, you say it's a personnel matter, does anybody know whether you're complying with the open meetings law? No, not at all. What we have advised, what the courts have agreed, is that a motion under that provision should include 2 components. Number 1, reference to the keyword particular, and reference to one of those qualifiers. I move to enter into executive session to discuss the employment history of a particular person. You wouldn't have to name the individual, but if you tell the world that much, what you're really saying is, yep, we've read the open meetings law, and unless we're fibbing, we are about to discuss a subject that may properly be considered during an executive session. Okay? Yes, sir?
Are there any time constraints placed on the executive session?
Nope. Some issues can be resolved in 5 minutes. Some of them take 3 hours. No. But I think you should be kind and considerate to the public. You know, if your executive session is likely to be 2 hours, I would save it until the end of the meeting, and I would say, we're moving to go into an executive session for a valid reason. This is the last thing we're going to do. And we're not going to take any action. If you want to hang around, so be it, you can, but you might as well go home. Yes? Yes?
The difficulty that I think we have with that, less so with this administration
I say that? I was gonna, but yes, you took the words stop right out of my mouth. The issue involves the ability of the public to speak. Well, lots of misconceptions about that too. As we look at the open meetings law, it contains a statement of intent, and it says in part that the public has the right to attend, listen, and observe the performance of public officials. The law nowhere refers to the right of the public to speak. So if a board does not want to let the public speak at all, that is within its discretionary authority. Now, most boards do permit some sort of limited public participation. When they do, our suggestion has been that they establish reasonable rules that treat members of the public equally, so that they can't say, we like you, we'll let you speak for 3 minutes, but the guy over there is a pain in the neck, we'll let him speak for 1 or not at all. The other point, and this comes up more at the school district level, parent gets up and says, Johnny's teacher is wonderful, we love her. The school board loves to hear that, right? What if the next parent gets up and says, wait a minute, my kid is the same teacher and the teacher stinks? What is the board going to say, especially on Long Island? They're going to say, shut up, go away, personnel matter, can't do it. No, because there are federal cases which indicate that if the door is open, it's all open all the way. If the board is willing to permit positive comments regarding its staff, it must permit critical comments as well. But if it wants to say, sorry, we will permit no comments that focus on specific teachers, that's okay. Everybody is on an equal footing. Okay? Public participation. You want to be kind? You can enable the public to speak at any time during your meeting. But I would make sure that it is consistent. Okay? Do you let Robert Ripp speak?
Yes.
Why? No, never mind. Did I say anything? Is he here? Oh, okay. Some people are constructive and some are not. We won't mention any names. What is another favorite ground for going into an executive session? You mentioned it a moment ago. Litigation. The law says that a public body may enter into executive session to discuss, quote, proposed, pending, or current litigation. Well, people have asked for a long time. What's the difference between proposed and pending and current? I don't know. You don't have to know. What you should know is what the appellate division told us years ago. You remember I said earlier that these laws basically say that everything is open except when disclosure would hurt. Well, that's the way the court looked at the litigation exception and said, what harm was the state legislature attempting to avoid? What the court held years ago was that the intent of the litigation exception is to enable a public body to discuss its litigation strategy in private, so as not to divulge its strategy to its adversary, who, after all, may be out in the crowd, right? Makes perfect sense. But the court also said that the mere threat or fear or possibility of litigation is not enough to justify an executive session. If it were, let's face it, there would be nothing left of the open meetings law. How many times do we hear, if you don't do it my way, I'm going to sue you? Well, unless and until the board begins to discuss what it would do in court if it were to be sued, there wouldn't yet be a basis for closing the doors. Okay? Also, I should tell you about a case involving a former reporter. I call him Let's Get Arrested Hendricks. Les covered the beautiful little town of Cobleskill. Anybody know where that is? Schoharie County? It looks like America. Yes, it does. He went to all the town board meetings, and they didn't want him to be there, and the motion proposed pending or current litigation, get out Les. He refused to leave, and they had him arrested. Well, the judge had to figure out whether the charge should stick or whether the board complied with the open meetings law. And this is what the judge wrote. And by the way, he is a federal judge now. He said that a motion for entry into an executive session cannot, quote, merely regurgitate the statutory language of the law, to wit, proposed, pending, or current litigation. Only a judge would ever say, to wit. He said that the motion must identify the litigation. I move to enter into executive session to discuss the case of the XYZ company versus the town of Cobleskill, or something like that. The notion is to give the public enough information by means of the motion to believe that there really is a valid basis for closing the doors. Okay? Any other exceptions that are critical in terms of what you do? Should we talk a little bit about after the meeting minutes? Lots of misconceptions regarding minutes. Have you ever faced a situation where so-and-so, a board member or a member of the public says, I want this comment to be included in the minutes? Has that ever happened?
Yes.
Yes. Do you have to do it? No. As we look at the open meetings law, it contains what you might view as minimum requirements concerning the contents of minutes. At a minimum, they must consist of a record or summary of motions, proposals, resolutions, action taken, and the vote of the members. They may include more, but they don't have to. They don't have to. And if so-and-so is so egomaniacal that he or she wants his or her comments to be preserved for posterity, you tell them, fine, bring in your recording device, the audio recorder, the video recorder. The law has permitted people to use those devices for years, so long as they are used in a manner that is not disruptive or obtrusive. The minutes, by the way, of open meetings, let me ask you, does your board approve minutes?
Yes.
Yes. Another myth. There's no law that says that minutes have to be approved. It's silly. It's Anybody know the word Michigas? It's Long Island. Everybody knows what it means, right? No? Yes?
That's a law word, right?
It's a Latin word, yes. It is. Yes. The Open Meetings Law says that minutes must be prepared and made available on request within 2 weeks of a meeting. 2 weeks. What if it's the practice to approve them and that hasn't happened? Simple solution. Whoever prepares the minutes, the town clerk, for example, must do so, make them available on request within the 2 weeks, and if they haven't been approved, fine. They can be stamped or marked, unapproved, draft, preliminary, something like that, so that the public has a good idea generally of what transpired, and at the same time, the public is given notice that the minutes are subject to change. Okay? If action is taken during an executive session, and that may be done unless the action is to appropriate public monies, the law says that minutes merely indicating the nature of the action taken, the date of and the vote of the members, must be prepared and made available to the extent required by FOIL within 1 week of the executive session. Okay?
If an action is taken?
Yes.
So if no action is taken?
If no action is taken during an executive session, there's no obligation to prepare minutes of the executive session. Okay. Let me mention one. Yes, sir.
And those minutes would be taken by the town attorney that would be present inside, correct?
You look at section 30, I believe it's subdivision 11 of the town law. If the clerk and or the deputy cannot prepare the minutes, I believe that anybody can prepare them other than a member of the town board. But
Can the clerk be present for executive session?
Good question. Under the Open Meetings Law, Section 105, Subdivision 2, the only people who have the right to attend an executive session are the members of the board. But that same provision says that the board may authorize others to attend. So if the board wants the clerk to be present, invites the clerk in, great. What if the board does not want the clerk to be present but wants to take action? Now, the town law requires that the clerk prepare the minutes if he or she is available and able. So what do you do in that situation? The board can deliberate in private. They invite the clerk in when the board is about to take action so that the clerk can prepare the minutes. Or again, the board could say, clerk, we'd like you to be here the whole time. Or the board could say, we will take our action after the executive session in public, where obviously the clerk has the ability to be present. Okay? Yes, sir.
Approving the minutes, you mentioned 5 days. What if
No, I didn't say that. I said there's no law that says that minutes have to be approved.
so it could be at the next meeting?
Could be never. Jamais.
So if there's standard practice, it's always been 30 days. It says standard practice.
You know, that's up to you. There's no law that says a word about the approval of minutes. We all do it, but there's no law that says anything about it. You want to do it within 30 days? Fine, as long as they're made available on request within 2 weeks. Okay. More. You brought up the communication with the attorney. Somebody did. At the end of the Open Meetings Law, Section 108, there is another vehicle that will authorize a meeting to be closed. It involves so-called exemptions. If a matter falls within the scope of an exemption, it's just as though the open meetings law doesn't exist. One of the exemptions pertains to matters made confidential by federal or by state law. So, if, for example, the board wants to seek legal advice from its attorney and the attorney is giving it, again, they will have created an attorney-client relationship under which the communications are privileged and confidential and therefore, to that extent, exempt from the coverage of the open meetings law. So that is a possibility. Certainly, a board can ask the lawyer for advice during the meeting. If they want to do it in public, that's fine too. That is fine too. More questions? Come on. Come on. I'm going to make you an offer you will never hear from a state employee ever again. Ask me anything. Come on. Make my day. Ask me anything. What time is it? We talked about 2 hours. Yes, sir.
If you provide an insert and you believe in good faith that you allow yourself, to comply with this is back and forth, a further request. But as you begin to prepare practice for first request, you discover that it's just insufficient.
You contact a person and you say, I didn't think that, I thought that I could complete the task by X date. It is much more complex or time consuming than I thought. I can probably do it by such and such. Are you willing to accept that? I think the human touch is critical. And I think that most people would understand that. Alternatively, you might say, we can make some of these records available on a piecemeal basis. Often that will be acceptable as well. But most people, if they feel that you will comply with law, you'll disclose what you're supposed to disclose, they're willing to wait a reasonable time beyond whatever it may be as a means of avoiding costly, time-consuming litigation.
It's a practical answer, very helpful. But if they're determined that you have to comply until the date that you said, it would be.
They could go to court if they want to go to court, or yes, appeal to whoever the appeals person might be. Correct. Yes? I thought we were done. No.
No, I think this is a good, wrap-up question.
A wrap-up question.
I think
In her view, we'll see.
I think over the past decade, we've taken some head sense of criticism for not complying, allegedly not complying.
Go figure. Yes.
Some maybe deserved, some maybe not. How are we doing, in your opinion? What can we do better? What improvements can we make? What do you think as of where we are now?
Wow. You're in a different place now than you were a year ago. That is, it seems to me, unquestionably so. Based upon conversations that I've had with some of you, there's still a long way to go. There's still a long way to go. The issue, to my mind, generally involves recalcitrance on the part of various officers or employees of the town who may not be willing to listen to people like you or Jim sitting next to you. People within government have various roles to play. You have various roles to play too, and there has to be a recognition, an understanding, and appreciation of that. What's going on in Oyster Bay? Not a secret. Not a secret. And I have described Long Island, should I be mean and cruel? I think Long Island, Nassau, and Suffolk, I refer to them as the land of hostility. I think Long Island has become a tough place to live. In so many instances, it has seemed that people would rather sue than talk for 5 minutes. That's part of the subculture here. I grew up part in Long Island. You know what I tell people? This is nasty. I think it's a good place to be from. Cruel and nasty. I think that your question involves consideration of a process, and the process is evolutionary. It's evolutionary. Nothing will ever be perfect at any given time, but we do our best to make positive change. We do our best to comply with law. We do our best to throw the rascals out if they warrant being thrown out. And some of that has occurred in the town of Oyster Bay. We've seen some of that in the town of Hempstead. We see, it's not a secret. Mangano he was charged. Strange things happen on Long Island. What can I tell you? Strange things happen on Long Island. And part of the reason somebody asked me about this before we began, I think that there is too much wealth. There is so much wealth on Long Island, the well hardly ever runs dry. And when there's that much wealth, there is a tendency, let's put it that way, to be, let's say, a little bit more corrupt than where things are not quite so easy. You know, you think about the administration in the Roslyn School District years ago. Remember the superintendent? But nobody was looking. Nobody was looking because in Roslyn, everybody's loaded, for God's sake. We don't care what, you know. If people cared more, you know, maybe we'd have a little bit better government. I don't know. And we are not unique. You know, people like to say, oh, God, it's New York, we're the worst in the world, we're the worst in the... You know, think about Illinois. How many governors are in jail? Think about Connecticut. What we experience here is, in my opinion, not significantly different from what we see in so many places. You read the New York Times or the Wall Street Journal. How many world leaders are you know, involved in scandals of one sort or another? Everywhere. So, you know, all we can do is attempt to do better and comply with law. But that was a good wrap-up question. Thank you. Any more? Last licks. Huh? How many, are the Yankees going to beat Texas tonight? What do you think? Who said yes? You know, it's a funny thing. When I was this big, we could hear Fenway Park from where we lived. And I've been a Red Sox fan forever. And we moved to Long Island when I was 9. There was a language barrier, number one. And number two, it was the 50s. Yankees won every year and the Red Sox won nothing. But I stuck with them. And therein lies the basis for, let us say, rooting for the underdog. Forever. So there you have it. I'm going to make you the offer again. Use the website with impunity. If you have a need to pick up the phone, please do so. Ask for either myself or Kristen. We'll be happy to help. And if the issue really involves FOIL or the Open Meetings Law, chances are pretty good that we can answer on the spot. So, thank you. Thank you for having me. Now we've satisfied the court order too, haven't we? Thank you.